Mr. Deputy Speaker, many MPs have asked what this dispute is about. That's a very good question. On what to do with the House in the future, the committee is studying a range of options. What is so wrong about that? DPM Teo has said that he personally would not support options at either end of the range. At the one end, preserving the House for visitors to enter and see, which would be totally against the wishes of Mr. and Mrs. Lee. On the other hand, demolishing the House and putting the property on the market for new private residences. Initially, Mr. Lee Hsien Yang said he had not thought beyond demolition. If that is true, then he couldn't have ruled out redevelopment. Then he later said that before the MC was formed, he had offered a memorial garden. So it appears that he had thought beyond demolition earlier. He did not make it clear if a garden is still his position now. After I pointed out the 4 possible options for the property, including the fact that demolition clears the way to appeal for redevelopment, Mr. Lee Hsien Yang now says that he has no inclination to develop the House for profit. Inclination is a word that leaves a lot of room for change of mind. Why is he being so careful? If he changes his mind, then the land is potentially worth a lot. Why doesn't he just rule it out categorically? But let's take his statement at face value and see what else Mr. Lee Hsien Yang said on Saturday. His exact words were, preservation of the House would be trampling on Mr. Lee Kuan Yew's values, and it would be an affront to these same values to develop a luxury LKY condominium. Well, isn't that exactly the same thing that DPM Teo had said, leaving aside the bit about values? In other words, no total preservation and no development. If that is the case, and if he's saying exactly the same thing as DPM Teo, where is the dispute? Both agree that the extreme ends of the range are out. So if the Ministerial Committee is studying the intermediate options within the range, what is wrong with that? Nothing has been decided. How can studying these options be an abuse? On the will, the concern of Mr. Lee Hsien Yang and Dr. Lee with the Ministerial Committee and their allegations appear to have been triggered by questions on the will. Why are they so concerned? We know from the facts disclosed that issues have been raised with regard to the will and who drafted it. If it was drafted by Mrs. Lee Swet Fern, then an issue arises because she is the wife of Mr. Lee Hsien Yang, and his share of the estate was increased under the last will. Under our law, the lawyer drafting the will is required to be independent. As our Court of Appeal has said, the preparation of a will involves serious professional responsibilities which solicitors must uncompromisingly observe and discharge. So if a lawyer has an interest in the will, the lawyer must make sure that the person making the will gets independent advice. Some have said, but Mr. Lee was a very good lawyer. He was Cambridge educated. Are you saying he did not know what he was signing? No one is saying that at all. That is not the issue. The issue is whether he received independent advice as the law uncompromisingly requires. And we do know that Mr. Lee had consistently in his lifetime taken independent advice for his lawsuits and for his first 6 wills. So the issue of whether he was independently advised is a serious issue. However, it is not for the Ministerial Committee or Cabinet to decide on this issue, nor is the Ministerial Committee or Cabinet attempting to do so. DPM Teo has already explained that the Ministerial Committee looked at the will as part of trying to understand Mr. Lee's thinking on the matter. The terms of the will, insofar as they relate to the House, would be relevant to that. The siblings provided different views on the drafting of the will. Each party was given the opportunity to comment on the other side's views. As is only fair, you cannot hear one side without hearing the other. But the committee is not conducting an investigation, and DPM Teo made it clear that it is not for the committee to decide whose claims are valid. It is simply trying to understand as best it can what were Mr. Lee's wishes. So really there is no basis for the allegations that have been leveled against the Ministerial Committee. Mr. Peng Eng Huat read out a catalogue of allegations from the internet. I would like to know, is he associating himself with these allegations or simply regurgitating them? If he's adopting them, then please put forward some specific evidence. Mr. Peng also referred to allegations that improper influence had been asserted over civil servants. This is a very serious allegation, not only against Ms. Ho Ching, but also against the permanent secretaries and senior civil servants as well. There are clear rules within the civil service to guide the conduct of public officers. Mr. Peng referred to the cataloguing of Mr. Lee's items. MCI had explained this last week. The involvement of MCI photographers is in line with MCI's policy of supporting former prime ministers and presidents after they leave office. After Mr. Lee's passing, MCI photographers were deployed to take photos of various personal and official items belonging to Mr. Lee at 38 Oxley Road. This was done for the purposes of national archival and documentation. Similar photographic recordings were done during Mr. Lee's lifetime of his study at home and of the basement dining room. If there are any specific instances of alleged impropriety beyond that, these should be identified rather than making general, unsubstantiated allegations. The government takes this very seriously. There are stringent rules in place and serious consequences for those who have been found to have contravened the rules. I move now to conflict of interest. Questions about alleged conflict on the part of the Attorney General were asked. The laws and the rules on conflict are very clear. These rules on conflict will be observed. The Attorney General and Deputy Attorney General Hari Kumar will not be involved where there is any conflict. They have abided by the rules of conflict, and there is no basis to suggest that either the Attorney General or the Deputy Attorney General have not observed these rules. An example of how the rules work would be when lawyers move from the AGC to the bench and vice versa. So take, for example, former DAG Tan Seong Tai, who was from the AGC. He recuses himself from any AGC-related matters now that he has returned to the bench. Likewise, the Chief Justice in relation to any matters he handled when he was at the AGC. Similar rules apply in private practice as well. If a lawyer moves to a new firm, he observes the rules on conflict. He doesn't involve himself in his new firm on matters which his old firm had acted. This has been debated before in relation to the appointment of the Attorney General and the Deputy Attorney General. Mr. Lucien Wong, we've already referred to his credentials previously. He was a senior partner of the largest law firm in Singapore. He is widely acknowledged as a top legal mind, consistently recognized as one of Singapore's best, and his appointment was welcomed by the bar. The Law Society has called him a formidable and creative legal mind with proven management skills, a practical track record, and a skill set uniquely equipped to deal with the evolution of the changing legal environment in Singapore. As a lawyer of almost 40 years standing, Mr. Wong would have had thousands of clients. There is no reason why this should be an excuse for us to pass him over and choose a less qualified candidate. Similarly, Mr. Hari Kumar is amongst one of the top 6 to 7 litigators in Singapore today. If you look at the people from within the service who have been appointed to key positions, the DAG and the SG as well, these are young, some of them in their 40s. and we hope that in the future, from among their ranks, someone can become Attorney General. Mr. Wong's appointment as Attorney General was decided after a thorough and rigorous process. The Prime Minister consulted the Chief Justice and the Chairman of the Public Service Commission and the incumbent Attorney General on the appointment. The CPA unanimously advised that the President concur with the appointment. The Council of Presidential Advisers, that is, unanimously advised that the President concur with the appointment, and the President, acting in his discretion, also supported it. It is also not unusual for the Attorney General to be known to the ministers or the Prime Minister. You will recall that our first law minister was very successful, being one of the, you'll recall that the law minister, Mr. Edibaka, was very successful, and one of our founding fathers was an old friend of Mr. Lee Kuan Yew and a partner in Lee and Lee. This did not prevent him from being a good law minister. With respect to past judicial appointments, these have included lawyers who acted for Mr. Lee Kuan Yew, such as Mr. Joseph Grimberg, or who worked in Lee and Lee, for example, Justice Lai Kew Chai and Mr. Andrew Ang, who's currently on the bench. All were or are well-respected members of the bench. Former Chief Justice Yong Pang Hao was an old friend of Mr. Lee's from Cambridge. He is credited with modernizing the Singapore judiciary during his time on the bench. In these roles, all of them observed the appropriate conflict rules. Ultimately, the most important considerations are the quality, character, and integrity of the individuals involved, and that is the hallmark of our system. And indeed, in many first world countries, the AG is even a sitting member of parliament or a politician. In the UK, the Attorney General is a cabinet minister, likewise, similarly, in Australia. Our system is based on a slightly different model, but as we've said before, it goes too far to suggest that AGC officers must not have previously had any links with any ministers or political party. On the questions about alleged conflict regarding Minister Shanmugam, on Mr. Low Tak Yang's comment of him being Mr. Lee's friend, well, being a friend of Mr. Lee Kuan Yew does not disqualify him from doing cabinet work, and this includes being in the Ministerial Committee to give views. The committee's role has already been explained. Mr. Low alluded to Dr. Lee Wei Ling's comment that Minister Shanmugam was a changed person. Well, she has said many things about many people, including the Prime Minister, members of Cabinet, and others. Singaporeans will look at the facts and reach their own conclusions. On the issue of whether Minister Shanmugam is somehow in a position of conflict, he has explained his position publicly on 17th June. In 2011, some members of the Lee family had approached him for his views about various options for the House. He shared some thoughts and suggestions with them. However, he also made clear to them that legally, the government had the full power to gazette or acquire based on historical significance, and that many Singaporeans, including ministers in Cabinet, were likely to take the view that the House should be preserved. He told them that this was also his strong personal view. At that time, Minister Shanmugam was already a Cabinet Minister. He was not consulted as a lawyer and did not advise them as clients. or Minister Mentor, had spoken with other Cabinet Ministers about the House as well. It will be absurd to suggest that they can all no longer participate in government work because they had spoken to him or some family member about the House. This is really a red herring, intended to divert attention away from the real issues. And so we come back to the key point. What is this dispute really about? The MC, or the Ministerial Committee, is not making any decisions. It's putting up a range of options for Cabinet to look at. Nothing needs to be decided now. Indeed, nothing can be decided now, as Dr. Lee is still living in the House. That might take 20 to 30 years. Therefore, the House cannot be the reason for the dispute. The trigger for all the allegations by Mr. Lee Hsien Yang and Dr. Lee appear to be something else. Whatever it is, that is no reason to drag Singapore and Singaporeans through this dispute. That is contrary to Mr. Lee Kuan Yew's values. Mr. Leon Pereira gave the analogy of a company and its shareholders, and he asked why the whistleblowers are not being interrogated by the CPIB. That is the wrong analogy. If something is really wrong, then the correct thing for the whistleblowers to do is to go to CPIB and file a report. That is the way it should be done if you think that there's something wrong. Or if anyone else thinks there's something wrong, you can file and lodge a formal report. The CPIB cannot be expected to look into unsubstantiated allegations. And on the Ministerial Committee, Mr. Leon Pereira may wish to look again at DPM's speech today, where he explained the role and the terms of reference of the Ministerial Committee. So what do we have at the end of the day? At the end of today, we've had one full day of debate. Mr. Lee Hsien Yang and Dr. Lee Wei Ling have made plenty of allegations, but we have not seen any substance and no evidence. And in Parliament, no one has said that there is any evidence of abuse. I'm sure that the MPs have all looked carefully through the allegations. In fact, Mr. Low himself had said that the siblings had presented no evidence. And to me, that is most significant, because it shows our people that these allegations are just that, allegations. Thank you.